Hello everyone. This video is all about the polity questions that were there in the prelims on 5th June 2022. The previous video was about the cutoff wherein I declared a cutoff. Though CSET paper was little difficult and it will be influencing the overall cutoff, but still my hunch feeling is that the cutoff will be little higher. But anyway, performance you have given, but now you need to wait for the result and you must not take break. After 2-3 days, you must get into the mains preparation and it will be useful for next year. And this approach that I am discussing for the polity specific question will also be useful for the next year. So without wasting much time further, let's discuss about the questions. The controversial questions I have also included, but to begin with, these are the questions which are related to the facts as well as the basic one. So the first question was related to the contempt, and it is saying that the 4 statements are there in it, and it is saying that H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed, right? So it is correct or not that you need to tell. And then Constitution of India empowers the Supreme Court and High Court to punish for the contempt of themselves. You must know that contempt means that the decisions given by the court must not be given disrespect, and not at only that, it must be followed in letter and spirit. If not, then it will be considered as contempt. Means court has given the decision, you are not following it, it is a contempt. Now the second statement is about the fact that, not second, the third one, the Constitution of India defines civil contempt and criminal contempt. Basically, you can recall one of the scenario in Corona time when Chief Justice of India was giving a picture without helmet, and then it was objected to by a very famous lawyer, and that lawyer was belonging to one political party. It was the stunt or not, so ₹1 was fine in last. So it was contempt in the legal book, but it was made use in the manner that media was giving hype to it. Okay. Now the fourth statement, that in India the parliament is vested with the power to make laws on the contempt of court. Basically here the answer is B, 1, 2 and 4. Why? Because the Constitution of India, the third statement is wrong. This is correct. Because the Constitution of India does not define criminal and civil contempt. Okay. Because of the fact that parliament is empowered to make the laws with regard to the contempt, then the definition for civil and criminal contempt will be there in the law made by the parliament. So the hint was hidden in it, but given the fact that you have been given 2 hours and many questions are with the four statements and combinations are there, so it make little difficulty, right, for the overall performance. Now we can go for the next question. The answer is here in the second slide. The next question is about the fact that the government law officer and legal firms are recognized as advocate, but corporate lawyers and patent attorneys are excluded from recognition as advocates. Basically, this is not belonging to the core polity, not to the constitution also, not to the conceptual frame given by the constitution. It is something which is related to the legal fraternity, and from the judiciary also they can ask the question, right? It is very rare question which UPSC has asked in the overall frame of the polity in prelims, right, for civil service exam. But anyway, the second statement is saying that Bar Council have the power to lay down the rules relating to legal education and recognition of law colleges. Now, which statement is correct? Basically, it is an informative question. Both the statements are correct, but still the controversy is there, given the fact that many bylaws are there and many decisions have been given by the court. But still, I will go as per the basic legal document, the definition, and the government law officer and legal firms are recognized as advocate. This is sure. and corporate lawyers and patent attorneys are excluded from recognition as advocates. This is also to an extent correct. Why? Because of the fact you must be recalling Attorney General of India. What is the meaning of attorney? The company is represented by one advocate, and that person is called as an attorney. Here the government is represented by Attorney General of India. So one is attorney, right? And there is a question also related to Attorney General of India. I hope it is clear to you, and the answer is given here. Now the third question is again related to the dictation that I give in the class. And I also categorically tell that yes, this is very, very important. It is related to the types of bill, constitutional amendment bill, right? So a bill amending the constitution require prior recommendation of the President of India. I always tell that this is money bill which requires the prior recommendation. An ordinary bill related to Article 1 and 3 requires prior recommendation of the President for its introduction. Constitutional amendment bill, both the houses are enjoying equal legislative powers, and there is no provision for joint sitting also. There is no requirement for prior President recommendation. So hence statement 1 is wrong. And when a constitutional amendment bill is presented to the President of India, of course it is obligatory for the President to give his assent, and it was categorically decided by the court also. Because when Jawaharlal Nehru ji, means Chacha ji, the then Prime Minister, passed away, and the tussle was there that who will become next Prime Minister. And Madam Prime Minister were also there. There was syndicate, there was indicate. Emergency time was also following. And when there is a law in democracy, judiciary has to take the strong position. And that is why such decision was given. When constitution was attempted to be played in a format that constitution is a toy, then definitely one has to come forward. And it is what that one organ has to look after the overall impression of the democracy. And 3 organs are there: legislature, executive, and judiciary. Okay. So this is something that when the constitution amendment bill is presented to the President, it is obligatory for the President to give assent to it. Now the third statement is the constitution amendment bill must be passed by both the houses, Lok Sabha and Rajya Sabha, by a special majority, and there is no provision for joint sitting. This special majority is 2/3 present and voting, and that too half of total strength of the house, right? So which one is to be correct? Now 2 and 3 statements clearly. So third is correct and 2 is correct. This is not correct because President prior recommendation is not required for constitutional amendment bill. Now constitutional amendment bill, you know that it is under Article 368. To delete or to amend the constitution, to bring new provision in the constitution like Article 21A, we use Article 368. I was pretty sure that there will be a question, and just 3 days before 5th of June, I made a video on doctrine of basic structure, and from that video, this question is coming. Means not the direct one, but forward and backward linkages are there. Now coming to another question. The Constitution of India classifies the minister into 4 ranks. This is the first statement: Cabinet Minister, Minister of State, and Deputy Minister, right? The total number of ministers in the union government, including PM, shall not exceed 16% of total number of member in the Lok Sabha. I always tell in the class that the Prime Minister is the son, the first rank minister, second rank minister, third rank minister, and fourth rank ministers. First rank minister, cabinet minister, second rank minister, ministers of state, third rank minister, deputy ministers, right? But it is not mentioned in the constitution. Indian democracy, Indian parliamentary system is following something what is called as conventions, right? So this is something out of the convention which is followed in Britain also. Okay, that is why we have made this convention that we will be having the category of the ministers, and these cabinet ministers are having right to attend the cabinet meetings. They are given sometimes independent charges, means for most of the time. Say for example, railway minister, finance minister, defense minister, they all are cabinet ministers. Okay. Now the second statement is saying that, so the first statement is wrong because constitution is not classifying it. It is the convention which is having the such category. Total number of ministers in union government, including the PM, shall not exceed 15%. Basically, this is something related to anti-defection law. And I give always an expression, something called as less government, more governance. I need to change the ink. Yeah, so less government, more governance. If number of ministers in the council of ministers are less, it is easier to coordinate. Okay, so 15% of the Lok Sabha means Lok Sabha today having 543 and 15% of it, say for example 10%, making it a total of like 54, and 5% it will be 27. So it will be making a total of how many people here? So around more than 81. So around 82 people will be coming as part of 15% arrangement. So that more and more ministers are not included in Council of Ministers because coalition form of government is there. Many parties are there in the government. So every party giving support to the party which is having more and more seats. They want that in return of support, please give us this ministry and that ministry. And that is why one of the madam from West Bengal who became chief minister from the railway ministries, you can understand that becoming an MLA from MP was derogatory in every sense, but it is opportunistic polity and politics. So that is what is the case. So in anti-defection law, every day you find some of the examples. So this statement is correct. So this was overall limit or cap put on the size of the Council of Ministers. So it is not inflated like a sumo pehlwan, 550 kg pehlwan, right? This is Council of Ministers. We don't want person like this. We want a very lean and thin person, but a smart person like Bruce Lee, who is having more energy in the body. And that is what government is all about. Now coming to the next question. So the answer will be only two, right? This is not there, this is not there, this is not there. Now the next question, which of the following are the exclusive powers of Lok Sabha? I always represent the parliament like this. It is Lok Sabha, it is Rajya Sabha and President. To ratify the declaration of emergency, this is the ratification, means approval for the declaration of emergency is exclusive power of Lok Sabha. This is wrong. Even if Lok Sabha is not in session or has been dissolved, right? It is Rajya Sabha which can ratify the declaration of emergency under Article 352. It is hinting, right? The national emergency. Now to pass a motion of no confidence against the Council of Ministers, yes, because Council of Ministers is responsible to the Parliament or Lok Sabha or to the President or to the Rajya Sabha. Council of Ministers is responsible to Lok Sabha, right? So this statement is correct. To impeach the President of India, this is also not correct because both the houses of the parliament enjoy the separate powers. So one house become the investigating house for the impeachment of the president, which is very hard process, right? So what can be correct here? So exactly, so I was confused. Only second statement is correct, because to impeach the president of India is wrong, and this is also wrong. Okay, now we can go for the next question if it is understood to you. With reference to anti-defection law, this is LAW, consider the following statement. The law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the house. This is wrong, because when MLA or MP, right, nominated one, has to ensure his or her career, one has right to make relation with the political party or becoming an independent candidate, so that he or she can ensure his or her career for next 5 years or 6 years. Okay, so that is why within 6 months one has right. Okay, but beyond 6 months, if one is joining any political party, will be disqualified under anti-defection law. Now the second statement is saying the law does not provide any time frame within which the presiding officer has to decide a defection case. Basically, in anti-defection law, this is correct, but Supreme Court has said in 2019 that the 3 months timeline is there for the presiding officer to decide the cases related to anti-defection law. But anti-defection law is not saying things about it. So basically, if one is wrong, second is correct. So B is the correct answer for this question. Now coming to here, the second statement is correct. This is not correct. Now consider the following statement. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meeting of the Parliament of India. Wrong. Attorney General and Solicitor General, you know that they are the highest legal officers. Attorney General being the constitutional post, and they are basically presenting the government in the court as if one has put case against the government, then the government has to be defended, and that is why Attorney General as a lawyer is there for the government. And as and when government is changing, generally Attorney General is also changed if the political party is different, but it is not a convention, not a legal frame that one has to compulsorily put the resignation. And this is the second statement, that according to the Constitution of India, the Attorney General of India submit his or his resignation when government appointed him resign. So both the statements here are wrong. And you must be noticing that there are other officers, say for example CAG, who is friend, philosopher and guide. Okay, he submits the report to the Public Account Committee. Okay, so the government expenditure is audited by CAG, has the right. Any other officer can also be appointed. They are assisting, say for example in Railway Ministry, many officers are there. So they don't have right to ask the question, but they have right to attend the meetings, if at all permitted by the cabinet. Now coming to the next question. With reference to the writs issued by the courts in India, consider the following statement. Mandamus will not lie against a private organization unless it is entrusted with the public duty. Under Article 32 and 226, I have told you about the writs, that is habeas corpus, mandamus, quo warranto, prohibition and certiorari. Okay, so mandamus means what? To command, And to command means what? The judiciary will be commanding the insensitive executive who is not working. The roads are not repaired in time, water you are not getting in time, electricity you are not getting in time, you are complaining to the government, no one is hearing, then you are going to the court, then court will be asking the executive. This is all about mandamus. But it is not lying against the private organization. Say for example, the Baba Ramdev Chyawanprash is not working for your memory. You cannot put case against Patanjali. Okay. So that's how this question is all about, that mandamus will not lie against a private organization unless it is entrusted with a public duty. This is correct. If Chyawanprash government is providing, right, under the midday meal scheme or something like that, then it has been entrusted with the government duty. Then you can put the case. If children are suffering out of the government scheme and Baba Ramdev Chyawanprash has been included as part of midday meal scheme, then for sure mandamus will be applied. Other than that, purely private, not applied. Then second one is that mandamus will not lie against a company even though it may be a government company. No, it is not correct. Even if you talk about 2G spectrum, the court told that this 2G spectrum, the missile is going and the missile has been launched using the money which was tax money, people's money, and you are allocating it to the private companies like Reliance and every other company. It is not that it is a private commodity. The government company indirectly has been included. Mandamus will be applied. Right? Now, third one, any public minded person can be petitioner to move to the court to obtain the writ of quo warranto. Yes, it is correct. So 1 and 3, C is the correct answer. I think we should not give more time to this. In the general class dictation I am giving, you just please read those notes, you will come to know about it. Okay. The next one, with reference to the deputy speaker, please go to the dictation that I gave in the class. You will find this answer. We can read the question. Statement number 1. As per rules of procedure and conduct of business in Lok Sabha, the election of deputy speaker shall be held in such a date as the speaker may fix. This is correct. There is a mandatory provision that the elections of a candidate as deputy speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. This is a mandatory provision. It is not correct. It is again part of the convention, that if a speaker is coming from ruling party, then deputy speaker will be coming from the opposition or vice versa. This is the arrangement so that reciprocation is there and there is a fairness so that they both are balancing the monitoring part of the house. So this is not a mandatory one, but it is a convention, and convention is like blood and flesh, which is like providing cloth or providing the lubrication effect to the dry skeleton of the constitution. So that's how convention are working, and no constitution can provide every legal term for every situation. There will be n number of n new situation and convention has to be developed, right? Now, the third statement, the deputy speaker has the same power as the speaker when presiding over the sitting of the house, and no appeal lie against the ruling. This is also correct, but no appeal lie against his ruling in court. This is wrong, but this has been omitted, so we will be considering it as correct one. Now the fourth statement, the well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and duly seconded by the prime minister. So where we are going? So the answer will be as per the rule of the procedure. This is correct. So this will not be the correct one. This will not be the correct one. And if we talk about second one is not correct. Here the answer is third. Deliberately I have shown you that how I am reaching to the correct answer by the rule of elimination. And in such question, rule of elimination is working. You can see this. Now we can go for the next question. In the Government of India Act 1919, which is called as Montague-Chelmsford Report also, you can remember that historical underpinnings. This is the first chapter that I cover in class. In the dictation, if you go, I talk about diarchy and bicameralism, and I said this year that this question will be there, and it is there. Now you have to tell that the reserved and transferred subject. So I also made this diagram, and I told you that the reserved and transferred subject, you just can go to the recorded class and just you can make the same screenshot that I told it or not. The reserved subjects, the list is there, and in that I told that the local self-government, which is of course part of the transferred subject, and if you remove this, you will be reaching to the correct answer, that is 1, 3 and 4, because the combination is talking about minimum 3 elements out of the 4, and if second is not there, which is belonging to the states today, and that time provinces, that frame. So of course the answer will be C. But administration of justice, land revenue and police, the money pocket, I made this figure, right, like the honey, and the police, the power, money, these are the main factors. The administration of justice that were kept by the white people with them, and it is the compulsion out of the World War promises they had to extend the Montague-Chelmsford report, and that is why such arrangement was made. The diarchy was included, that not to in the true sense, but at this place. Extremists told that Gandhiji to the Gandhiji, Bapuji, that they are making fool of you, but Bapuji told that I know, but this is the time when we need to accept this. So anyway, now coming to the next question. In India, which of the following compiles information on industrial dispute, closure, retrenchment and layoffs in factories employing workers? Right. The answer is basically Labor Bureau. This is, you can say, current affairs question, you can say governance question, right? But all in all, when you read the newspaper, when you read the current affair, you have to make a note for the bodies and organizations that what function they are imparting. Okay. Nothing is to be told in this. It is a factual question. The next question is about the Coal Controller Organization, CCU, and they are giving the 4 statements here. It is the major source of coal assets in Government of India. Basically, there was coal scam. You can remember in 2012 time, it was a big scam involving thousands of crores of rupees, and 2G spectrum was also there. That is why in 2014, the change in government was there. And it was giving momentum to the then Damini case, the Delhi gang rape case in the moving bus, right, which herald even our today's happenings. So anyway, so CCO is working from that time very effectively, and all the 4 functions were directly and indirectly coming into this fold. But still, we have to go as per the record. Then we can find here. Sorry, the description for it, you can say that CCO has to reach as an organization to the last man, and before that the transportation, maybe by bus, maybe by train is there. They have to have the compliance of it, and this end user can reach to CCU as an organization. So there will be a statement regarding this. It monitor the progress of development of captive coal and lignite blocks. So captive mining, you must be knowing that if the allocation of mine is there in the limit, one person can explore an area to take out the minerals, including the coal. Okay, so this is something called as captive mining. And lignite blocks, basically you might have heard from the Jharkhand area, there is a specific class of coal called as bituminous coal or BCM coal. So there are types of coal, and these lignite blocks are providing very enriched type of coal, very expensive one, and particularly used in some of the industry, not today that much because it has been replaced by the steamed engine technology. So the steam is used to propel the propellers and all, be it of electricity or of any factory. So the third statement is talking about it here. Any objection to the government's notification relating to the acquisition of coal bearing areas. Fourth statement is saying that it ensures that coal mining companies deliver the coal to end users in the prescribed time. So I told that this fourth statement, right, is correct or not, that deliver the coal to end user in the prescribed time. In the prescribed time, there may be some difficulty that one is reaching in time or not, but the quality, the legal frame, the legal promises that the company has made, definitely one can reach CO. So that is why this fourth statement is wrong. And the third one, if we have to filter out from A to C, it here any objection to the government's notification relating to the acquisition of coal bearing areas, then definitely yes, it is part of the legal promise. It monitor progress of development of captive coal lignite blocks, answer is yes, and it is a major source for all the data provided to the government of India. It is also correct. I hope that it is fine. It is not part of the legal professional thing. It is not part of the conventional polity topic. It is not part of the constitution, but it is of course part of governance as well as current affairs. Now, coming to the next question, if a particular area is brought under fifth schedule of the constitution, which of the following statement best reflect the consequence of it? It would prevent the transfer of land of tribal people to the non-tribal people. I have told you the difference between fifth and sixth schedule. Sixth schedule is for Assam, Meghalaya, Tripura and Mizoram, but for rest of the areas, schedule fifth is available and it is protecting the interest of the tribal people especially. And of course, this would prevent the transfer of land for the tribal people to the non-tribal people. Of course, the first interest is that their homogeneity, their population density is not disturbed by the outsiders, so-called outsiders. And this statement, this option is correct because there is no other combination of things, but still one has to look at the other options too, that this would create a local self-governing body in that area. No, this was not provided by fifth schedule, and that is why we brought something called as PESA, Panchayat Extension of Service, right? So PESA is a different topic altogether. Now C is talking about this would convert that area into union territory. This is also not correct. It will be bringing constitution into the picture, the constitutional amendment. The state having such area would be declared as a special category state. Special category state is a new concept altogether, nothing to do with the constitution directly. So hence this is correct. Now coming to the next and perhaps the last question. With reference to the United Nations Convention on Law of Sea, consider the following statement, though it is related to international relation, which is not part of the conventional syllabus of prelims, but when I discuss about Article 1 in the dictation also, and that day class also, you can rehear that I talked about EEZ, I talked about territorial water and territorial area, right? If it is India, we have to have the fisheries, the minerals, any Kuber ka khajana is coming, that is also belonging to us. So 12 nautical mile and then 200 nautical mile. These two concepts are here. you can read these three statements that a coastal state has right to establish breadth of its territorial sea up to a limit not exceeding 12 nautical miles measured from baseline determined in accordance with the convention. This is basically UNCLOS, right? And this is correct because we are considering that this is a land which is submerged under the sea. We have to protect our land, and that is why this land underwater is very, very important to us. Now, second statement, that ship of all the states, whether coastal or landlocked, enjoy right of innocent passage through that territorial sea. Doesn't mean that they will be coming in dark and without any information. They will be providing the information. Of course, they have right. Maybe some of the tax and all and other maintenance charge can be imposed. Say for example, Suez Canal Pass is there. Say for example, Run of Kutch, the disputed area we have from Pakistan side in Gujarat. This is also something coming under UNCLOS. Okay, and even the Sri Lanka, we have some of the close proximity from land to land border. The exclusive economic zone EEZ shall not exceed beyond 200 nautical mile from the baseline from which the breadth of the territorial sea is measured. This is also correct. I told you the natural region कि भाई मछलियां भी खानी है हमको, तो समुद्र में फिशरमैन को जाना पड़ेगा ना. लेकिन जब वो हाई सी पे चले जाते हैं, 12 नॉटिकल माइल को क्रॉस कर लेते हैं, फिर उनको दूसरी कंट्री की नेवी पकड़ लेती है. सो दिस इज all are coming under UNCLOS, right? So here the answer will be D only, and I think we have one more question left. We have to see with reference to the proposal of Cripps mission. Consider the following under the historical underpinning. Though history subject person will be saying that it is my question, but of course it is all about the facts given under this question coming from the constitution side only. That time what was the arrangement? So the constituent assembly would have members nominated by the provincial assemblies as well as princely states. It is correct because Cripps proposal talked about dominion status. Dominion status means half rule. Something from Britain side, something from India side, right? So the joint arrangement, it is correct. Any province which is not prepared to accept the new constitution would have the right to sign a separate agreement with the Britain regarding its future status. Of course, the instrument of accession, we got it signed from the princely states. Many princely states were not signing it with us. This was the arrangement at the time of Indian Independence Act also. Those princely states had the right to join Pakistan, to join India, or to be independent. Had this not been there, it was not India which was getting freedom. 565 princely states as country were liberated. You can understand, thanks to our Iron Man of India, Sardar Vallabhbhai Patel, became a pivot to bring them all together. So anyway, so both these statements here, we find them as correct one. Okay, so these all questions we are having. All in all, the questions related to current affairs and legal professional frame, which is part of judiciary exam. But every year you will be finding some of the questions wherein you have no idea. And this is what all exam, UPSC exam, civil service exam is all about. But anyway, I think the controversial questions were there, 2-3 questions. I will be making a separate video for some of the questions wherein the length and breadth is required, keeping in view that how the main level question can be framed out of the question that has been asked in the prelims. Till then, please enjoy. Already we have made video for the geography, environment and agriculture topic. Some of the videos will also be made for other subjects. And thank you so much for being with me. Jai Hind.